Hello, good morning. Welcome to today's webinar. My name's Amanda Chadwick and I'm the Senior Speaker at Peninsula Business Services Limited, an HR, employee assistance and health and safety consultancy, largest one in the UK. Handle over 3,500 tribunals a year, winning about 98% of those. And also integrating ourselves within many companies throughout the UK, from small businesses with one employee to hundreds or thousands of employees throughout the UK. We currently help nearly 28,000 businesses with employment law, HR, everyday issues, from sickness and appraisals to managing the odd dayers to even defending at a tribunal. In fact, we have a whole floor of retained legal experts that eat and breathe HR and employment law every single day, and another section for health and safety for our clients to defend them. So that's our background. The reason we're holding this webinar today on policies and procedures every business should have in place, because what we're doing, or I'm doing, is bringing the experience that we have in managing our clients and also defending at tribunal to show you how, if you get the right policies and procedures in place and you actually know how to use them, you could save yourself a lot of trouble. We can't stop malicious claims, but they are great at defending when somebody is making a claim against you. So I'm going to talk about those policies and procedures that I think you should be having in place within your contracts, policies and procedures. My background is I'm a speaker. I've been a speaker for over 20 years, specialist subjects employment law and health and safety, a specialist in incentive writing and motivation, and also the legal side of that, and also I mediate and also have defended in tribunal as well. So, okay, I don't do tribunal work anymore. So here we go. Hot topics on our advice line. We take about 60,000 calls per week on everyday issues, and that could be one of our clients ringing up saying, could you write us an advert please, or could you take us through the process of an interview? What do we need for an interview? What's the checklist? So these are the hot topics that people are asking us about. Well, we had Vince Cable going on about 0-hour contracts. It's highlighted it, so we've got a lot of clients, a lot of people ring us up asking if they're using them in the right way. And 0-hour contracts are fantastic if they are used in the right way. And what you have to remember when you start a business, the type of person you take on, the role they're going to take, will determine the contract that you employ them on. So if used in the right way, 0-hour contracts are fantastic, especially if you run a pub, you run a catering unit, you work in the tourist environment, and work is a bit hapdash. And also if you work in the care sector as well, and you have domiciliary care agency, a 0-hour contract works great because you're not guaranteeing the hours, and the working relationship works both ways. They can turn down work and you can refuse, you don't have to offer them work. Some people use these in the wrong way, and that's what Vince Cable's looking at, okay? So there's going to be a big highlight on 0-hour contracts. And what we've got to remember as well, there's different types of workers within a workplace. We've got temporary workers, fixed-term workers, part-time workers, full-time workers, 0-hour contractors, self-employed. And just a reminder there to anybody listening to me, in employment law, for all the years that I've been doing employment law, it's very rare that I actually come across somebody that is actually genuinely self-employed. And you have to remember that, because you might speak to your accountant who says, yeah, they're self-employed, but in tax terms they might be on paper, but in employment law terms they might not be. And if you are listening to me and you're wondering whether you employ self-employed, you speak to us. Volunteers as well. So with self-employed, what we're looking for is a clear relationship. Somebody invoices you for their work, you pay the invoice, they work for other people, you don't train them, you don't give them a uniform, you don't dictate the working hours. If they couldn't come in, they could send somebody else. So we're looking for a clear relationship. Generally, they fall into the category of worker, and they have quite a few employment rights, and what we like is a contract for services, which we write for our clients to clear that up and get clear water in place. Then we've got volunteers. We're looking for a volunteer agreement and an arrangement that's in place, and don't get carried away if you're using volunteers by treating them as an employee, because then you're giving them employment rights. So you've got to have a volunteer agreement in place. Fixed term contractors, errors that people make there with fixed term contractors are maybe getting rid of them before the expiry date of the contract, then having to pay them the full whack. So you've got to have some terms and conditions in a fixed term contract that allows you the luxury of being able to get out the contract early. We write those for our clients as well. Again, temporary workers, you know, there's all sorts of workers. You've got to remember who you employ and what type of contract suits them. Then we've got settlement agreements. They've replaced compromise agreements. It made it a little bit easier for you to have that conversation with somebody if you're not getting on with them, they're not getting on with you. Now, point taken here is ACAS do have a code of practice with quite a few things, but they also have a code with settlement agreements. Do not breach the code, else you'll find that the conversation can be brought up in a tribunal. So be very careful of that and seek help. Pensions and auto-enrolment, top of the list. People are talking about it because it's getting nearer their staging dates. You need to think at least a year in advance for pensions and auto-enrolment. Don't do it a couple of months in advance. There's not a lot of financial advisors are not getting involved in this because it's not worth the money. They're not getting a lot of money back on it, so they're not wanting to get involved. And the ones that are getting involved are actually really struggling at the moment with the workload that they've got, with people asking them questions. So for me in pensions and auto-enrolment, if I was running a business and I know that some of my staff will be eligible, then I'm really going to think about it well in a year in advance, you know. And also just a couple of top tips to remember here with auto-enrolment and pensions. The fines are very hefty. If you don't keep your, I was going to say children then in the loop, kids in the loop. If you don't keep your employees in the loop and tell them how to opt out, there are fines for that as well. We're seeing huge fines at the moment. Also with pensions and auto-enrolment, when you do auto-enroll your staff, you need to change the state and the main terms to include who the prevention provider is, and also in the employment law handbook you have to include mention of how they automatically get enrolled, how they opt out, and etc. about the pensions. If you don't, you're breaching it. So legally you've got to put that in place. Also check in who your workforce status as well, because as I said earlier on, you might think they're self-employed but they're not, and they should be auto-enrolled into pensions. So it might be a great time to check your workforce status. The other one is hot topics on our advice line is how to conduct a disciplinary. Back in 2004 the statutory dispute resolution procedure came in. That was a legislation where you had to have investigations, disciplinaries, appeals, and there was a clear route that you had to follow when you dismissed a member of staff, and if you didn't, you breached it and there were penalties. They made it simpler. In came the ACAS code of practice, which made it simpler for the employer to follow. But the problem is, you see, what you've got is that employers are still not following it, and also what they're doing is they're not actually, they haven't got written disciplinary procedures. I hope you can hear me because I can hear buzzing in my ear. You know, so just I hope that the sound is okay for you. So disciplinary procedures, investigations, appeals and grievances, and I want these in place within your handbook. Right. If you can hear me, I'm attempting to... Hello, I'm assuming I'm back on. Can anybody hear me? I hope so.
Welcome to GoToWebinar, Webinars Made Easy.
Hello, hi. I'm sorry about that loss of sound there for a second. I don't know what's going on. There's a technical issue, so I'm sorry about that. There's a technical issue with this webinar today, and I think you got up to pensions and auto-enrolment. I'm assuming that you can still hear me, and I really do apologise about that. So I'm going to watch the numbers, and if I see people logging out, I know you still can't hear me, so I'll carry on talking. Right, so how to conduct a disciplinary. We spoke about the ACAS Code of Practice. You've got to have that written into your handbook. Disciplinary procedures, the clear route of grievance procedures, investigations, and this really really why they brought that in was to stop you having a tribunal in the first place. Lots of employers just sacked people on the spot, didn't follow routes, and the tribunal said, hey, we've got to have something here to prevent people having a tribunal. So they brought in the disciplinary procedures. And again, apologies for loss of sound there for a second. There was a technical issue for some reason. It logged me out. So do apologise there. Okay, so disciplinary procedures, but legally you have to have them written down. They help you and prevent you from having a tribunal, and it's proof that you try to solve an issue. And I gave you a little scenario here. I work for you. I leave the company. I leave unhappily. I say, shove your job. I'm not working for you anymore. And you just allow me to leave. We've got to do an investigation and speak to that person as to why they're leaving. So we let them have time to cool off. We write to them. So we start a paper trail. We bring them back in to discuss why they're leaving. And then what we do is we document everything. We have a paper trail. So we want a clear route and paper trail. So disciplinary procedures, investigation, appeal, and grievance procedures. I also like to see a conduct and capability policy as well, because this clears up conduct, it clears up capability on the grounds of ill health, lack of dexterity, short-term illness, and training as well. And if you're using KPIs and appraisals, you can tie the capability policy in with that. So reducing suspension costs in the health sector, lots of people ringing us up about this. We've got to suspend our staff because we're told by the governing bodies we've got to, but how do we reduce the suspension costs whilst we do an investigation? We try and make it quick and swift for those people. Have I missed any major changes? So things like, changes in employment law and topical changes such as minimum wage, maternity, paternity, we always get calls on that. Flexible working is the hot topic this year. Flexible working would be coming in. It was supposed to be the 6th of April. It's been postponed. We're looking at spring this year, and it gives everybody the right to work flexible hours. But remember, it doesn't automatically give them the right. This is the key here. It gives people the automatic right to ask for it, and there is a list of things they have to do to request it. So that's writing into you, and there's a requirement of working with you for 26 weeks before they have the right to it. So don't be frightened by this flexible working. There's lots of other ideas now. We're looking at all areas of working. Traffic's absolutely terrible. Weather's terrible. Maybe people could work from home, have staggered hours, term time working, evening work, compressed hours. There's all sorts of hours that people can work, and you will attract the right staff. Your own staff might go, I'm not working at the weekend, and it might, ordinarily you might have paid them overtime to work at the weekend, but advertise the job now for weekend work with compressed hours without overtime. You might get a person that can fill that gap within your business. So flexible working, don't be put off by it. Don't be frightened of this new legislation. As an employer, you have rights. Remember, that's what Peninsula's all about controlling employment law for the employer, for HR, and trustees. So also the other question is checklist for new starters. Big focus now on tracking people, on driving licenses, on have they got the right to work in the UK. Literally the other day, they're so hot on illegal immigrants now and illegal workers. I see a van outside certain shops at least once every month. Drive along and there's the immigration police van outside certain industries, car washes, restaurants, maybe shops. I'm seeing them outside there when I'm driving all over the country, checking who's got the right to work in the UK. So you must be checking everybody, not just people with a foreign sounding name, different colour skin, or some sort of accent. You've got to check everybody else. That's racism. So have a starter checklist. Check who's got the right to work in the UK. Check the right documents. Check their driving licence with the DVLA. You don't want somebody driving a vehicle that actually isn't insured to be driving it, and the licence isn't valid anyway. And then also the health checklist as well. Health questionnaire only when you've offered them a job, and a health questionnaire for you is a defence document. For us, it's a very strong defence document if you have a health and safety issue or you're facing a discrimination claim. We know why we're providing these documents and how useful they are for us. I'm educating you today on why you should be using them. And data protection, huge news within the next 24 months. We live in a Big Brother society now. You watch these crime programmes on television and they say, let's check the CCTV footage of that day. You weren't driving down that motorway at that particular time. They know everything about you, where you've logged on, who you're speaking to. So Of course employers are getting involved in this. Of course employers are checking Facebook before they take somebody on. Of course they're checking your work history and making sure you're not lying. And companies are springing up everywhere where they'll check references. They'll check to see if your work history is right. And if you watch The Apprentice, you know, I love that scene on the CV where they say, you said you worked here for 10 months, but you didn't, you're lying. You know, and they call their bluff because they've done all those checks. Which employers actually check that, you know, people's history? And how many people lie on a CV? You've heard me speak about application forms and the importance of using them. And they've got to say that they're a legal document. People can lie on a CV because it isn't a legal document. Lie on an application form, it's fraud and deception. So start using those applications, that, especially our clients, we provide them to protect you. Start using them, use them all the time. They're an amazing tool and a great defence document for you. So application forms, start a checklist, and remember data protection. If you're recording your staff in any form, either through cameras, through tracking devices, through mobile phones, through the cars, through CCTV, if you don't mention it in your handbook, it's illegal for you to do it. So don't fall foul of the law. Get policies in place that say that, you know, that you record your staff, and also that you monitor emails, etc. So those are the hot topics on our advice line. So number one, Tom Tem, I told you I make words up as I go along. Top 10 common pitfalls in employment law: not issuing a statement of main terms. Okay, this is that document you give me when you offer me the job, saying where I'm working, how much I'm getting paid, my hours, my holidays, and I can't run my life without that document. My personal contractual terms with you. Can we change this later on? Yes, we can, but you need help and guidance and a business reason for doing it. Would you change it if somebody changed their hours? Yes, you would. Would you change it if somebody went part-time when they were full-time? Yes. Would you change it if somebody became a home worker instead of an office worker? Yes. If there is a change to somebody's statement of main terms, you have to make that change as well. Don't verbally change it. Make sure that you make the contractual change and get them to sign. And remember, many employers who find themselves with a tribunal claim or unfair dismissal claim find themselves with the added complication of failing to comply with Section 1 of the Employment Rights Act 1996, and that is issuing a written statement of main terms to the employee. This can be a costly error, as a tribunal can fine the employer the equivalent of 4 weeks' wages, and all because they didn't issue the employee with the correct documentation. The average award for failing to issue a statement of main terms is on about £1,428. Big price to pay just because you didn't issue that standard document when you first offered somebody the job. Lots of employers fail to do this. Excuse me. So top 10 common pitfalls. We've got written statement of main terms, not issuing it. Job description. How the hell am I supposed to know what I'm doing in a company if I haven't got a job description? So I'm looking for a job description with the job title and the tasks that I should be doing. We will then use that later on when we are completing an appraisal, sitting down with them and ask them how they went on. And when somebody says, I want a pay rise, you know, if you want a pay rise, then we have to justify that you're doing the job that we've paid you to do. So a job description is crucial. When you first take somebody on, it forms part of the contract. I'd like to know what my job is anyway, what my job description is, and you can use this with appraisals and KPIs. Standards and expectations. This is the handbook. This is the employee handbook. You know what? It's your business. At the end of the day, it's your business. You can have whatever you want in that handbook. That means that you can have rules in there. I've got over 80 rights as an employee the minute I walk through your door. Okay? You, the employer, you write your rules in place in the handbook. You haven't got any rights unless you write them down. And some of them are illegal requirements, such as legal terms and conditions, such as written rules and procedures, grievance and rules and procedures. These are legal things that you have to have written down on day one. But the other rules are things that you want to use, such as, you know, a suitability clause, a wastage policy, garden leave, etc. I also like to see capability policies and procedures, which you mentioned earlier on. Use the key performance indicators and appraisal systems. And if you missed my webinar yesterday, catch it on YouTube. I spoke about KPIs, appraisal systems, managing underperforming staff, and also incentives and motivation. So you might want to have a look into that if you don't have a clue what KPIs and appraisals are. Create a paper trail by using formal documentation and forms. So you must, on day one, start as you mean to go on. So what we're going to do when we offer the job is send out your job description, job offer letter, a statement of main terms and a health questionnaire. When you join us on day one, we're going to have an induction, and we're going to actually make sure that we get you to sign for all the documents, handbooks in place and training that you're going to have. And what we are doing is we're creating a paper trail. Any communication going forward, we don't do it verbally, although we're going to talk verbally, we're also going to write it down as backup as a defence document for later. And believe you me, you'll struggle. If you're not keeping things written down, you end up in a tribunal, you'll struggle because you'll be going, I did say that, I did say that. And they'll say, where does it say it? And remember, in a tribunal or a health and safety hearing, that you, the employer, you're guilty until you prove yourself innocent, and the only way you're going to prove yourself innocent is with documentation and proving that you did things. Okay, so training and education of management and employees, you know, training them on health and safety, training them on harassment and bullying, training them on managing stress and depression, training on looking out for people that might be underperforming. So the training and education of management employees is crucial. Where employers fall down, they don't train them, they don't educate them, they don't make people aware of what's right and what's wrong, and they have vicarious liability. So you must train your staff. Keep up to date with employment law changes as well. So what documents should you be using? We've spoken about the statement of main terms, the employee handbook, because that is your Bible for your workplace. These are my rules. You want the job with me, you know, these are my rules. And we've got to keep this constantly update. The most recent change we're going to put in there is flexible working, and also the pensions and auto-enrolment. Those are the changes we're going to put in there. What we might also want to consider is a whistleblowing policy because of pensions and people sort of whistleblowing on companies. We might want to update it because things change within our business, such as the use of mobile phones and technology, and we've also got a trend with lateness. So you've got to keep up to date with your handbook. Your business might change, where you're working might change, the people might change, your contracts might change, a law changes, and because of that the employment law handbook has to keep fresh. Don't tell me that you've had one for the past 5 years and never looked at it. Don't tell me you've never had one. I want you to get them in place, because really it does help you when you run a business. And then the application forms, and then also, by the way, any Peninsula clients listening to me today, you know, we put your employee handbook in place for you. If something is changing within your business, I don't want you to sit there struggling to try and write a policy. That's what you're paying us for. We will rewrite policies for you and update it. Remember that. That's what we're there for. When we walk away from your business, we won't know how your business changes unless you tell us, and then we can change your handbook. We can change it within any changes that are happening within your business. Application forms, why would you use them, you're thinking? Another document, hey Amanda, what a waste of time. No, it's not. Very powerful document. First of all, CVs contain a lot of information I don't want to read, okay? Lots of things. I don't want to know you go to the gym 3 times a week and you like going to the cinema. I think that's great and I'm really happy for you, but I'm not really interested in that. I don't want to know a big, massive letter of how you feel about things. I just want a standard application form with basic facts. Then what I'm going to do when you come for the interview is I'm going to have set questions I'm going to ask you anyway. But and then I'll gauge your personality from the interview, not from your CV. Okay, but the application form, what it does, it standardizes the questions, but also it stops you discriminating, and it contains a legal statement that makes it a legal document. Now, let me give you an example of a tribunal from a CV. Telephone answering service, and I use this all the time. A telephone answering service, a man sees a job advertised for a telephone answering company. He applies, he sends a CV off, and he sends it by recorded delivery to make sure they get it. He doesn't hear from them, they don't talk to him, they don't send him a letter or anything like that, and he's quite surprised that a few weeks later he sees the same job advertised. This time he sends a CV off, and he sends it by recorded delivery again. The only difference is the name change. It's a female name this time, but it's from him. She gets an interview and he didn't. Sexual discrimination case. Why does he get away with it? Because it's on a CV. It's not a legal document. Had it been on an application form, it would be fraud and deception. Hey, I've just helped you prevent tribunals in the first step. So, application forms, interview rating cards, we use those on day one to get the person that we want for the job. You should be using them. And then when somebody challenges you and asks you why they didn't get the job, you can refer back to your interview rating, because 2 weeks later you can forget about the interviews. Holiday request forms, sickness injury records, exit interview documentation. Why are you leaving my company? You can use this to find out about your business, but also at the same time to stop tribunals again. They can say they're leaving because they've got a new job with more money, but when they don't succeed in the new job, they turn around and say they left your company because they were being bullied and harassed. You've got a defence document that says we've got a harassment policy in place, which they saw on day one. Induction, they signed to say they'd read it and understood it, yet they never followed through the bullying and harassment procedures that we've got. When we held an exit interview on the last day of employment, they never mentioned to the person that held the exit interview, who wasn't the person they're accusing of bullying and harassment, that they were leaving because they were being bullied and harassed. They said they were leaving because they've got a new job with more money in the car. And after they've signed this document, by the way, and after further investigation, we have found out that they weren't actually successful in their new job. And we feel this case is money motivated. An exit interview document is fantastic. We would use that as defence. Staff appraisal systems and KPI systems are amazing tools to manage underperformance, to manage staff, to help them gather and to gather their dreams for your business and buy in within your company, to forward project where they can see themselves within your company. And by doing that, you're giving them objectives and you're giving them goals, and at the same time you're getting buy-in within your company as well. So they're not actually, thinking, oh, I can't see myself in my future with this firm. They can see a future. And also, it's a known fact, if you manage sickness or appraisals or underperformance at the earliest stages, it's easier to manage than it is long term. So let's implement staff appraisal and KPI systems. So, what policies would I recommend? Well, a sickness, injury, payment and conditions, and things like not texting in and doing return to work interviews from day one, because you're less likely to be off sick if you have to face your manager with a return to work interview. And if you do return to work interviews from day one, you're evidence gathering. So after 3 hits, you might have a word with them and say, look, you're suffering a lot of headaches. Is there anything we can do to help you? And just by speaking to them about it can stop them going off sick. And also, you're highlighting everyday trends as well. Disciplinary rules and procedures, capability policies and procedures, equal opportunity, bullying and harassment policies, because these are great defence documents, and there's a clear route if anybody's having a problem that they could go to and report that they're having an issue, and giving you the chance to solve a problem instead of ending up at a tribunal. A search policy, not just for stealing, for drug abuse, alcohol abuse, it's for drinking when they shouldn't be, smoking when they shouldn't be. And if you haven't got a search policy in place, I can guarantee you wish that you had one day when you want to check that they are using their mobile phone and you know it's in their pocket. You're not stripping them off, you're not taking the clothes off them, you're actually saying, please could you remove your jacket, please could you empty your handbag, please could you open the glove compartment of your vehicle, that type of thing, rather than, it's not an opportunity to undress a member of staff, let's put it that way. And let me just tell you, I have been asked that, I have been asked that, believe it or not. Social networking policy, data protection and recording. We've got huge questions on the advice line, people saying, can I have a policy in place for social networking? Can I have a policy in place for Facebook? Could I have a policy in place for mobile phones? Right, okay, let's clear this one up. And the search policy ties in quite nicely with this. Can I have a policy to tell people that they can't have my clients as friends on any social networking site? Yes. Can I have a policy that says they can't talk about my staff on any social networking site? Yes. Can I have a policy that says they can't say they work for me, but they can say what industry they work in? Yes. Can I have a policy that says that they can't have a blog on my company? Yes, you can. Can I have a policy that says that it's part of the bullying and harassment on any social networking? Yes, you can. You're not infringing on their human rights. You're protecting your business. It's a business need. Okay, next question. Could I have a mobile phone policy that says they can't use the mobile phone in the workplace? Yes. Can I have a mobile phone policy that says that they can only use it during their breaks and at the lunch? Yes. Can I have a mobile phone that says, can I have a mobile phone policy that says we give you a personal mobile phone policy and we give a separate one for work use that says you can't use your work's mobile for texting, taking rude photos, rude videos of yourself and sending them to your loved ones? Yes, you can. You know, you can do all that because it is your business, and it's a reasonable request to say that, you know, and they shouldn't be using the works mobile anyway for those type of things. They should be using that type of, they should be using, you know, I don't know if you want to do that, that's up to you, but that's for their personal mobile. You don't want photos ending up in the wrong hands, do you, and going to one of your clients. So, and also you can lose business with people putting pictures of themselves up on social networking sites and your clients seeing it. And, you know, the thing is, people allow their personal life to become public information now. I don't really care what you get up to in your private life. You know, that's up to you. And I think it's really sad when it involves itself with work. And I think what you do in your spare time is your private life. And I want to keep it private away from work. So, you know, I don't want you to mention that you work for me if you participate in, you know, very colourful activities. Just tell them what industry you're working on Facebook. Just don't say you work for me. And that's a requirement you can say. So, maternity policy. Do we have a huge maternity policy? But we also have a maternity statement as well. Steer clear of saying how much somebody gets paid for maternity, because you'll find yourself changing that policy every year when maternity allowance changes and payments change. I like to just have a maternity statement because people tend not to tell you when they're pregnant. They wait for their 20-week scan, then they tell you. So what I like to see is I like to see a statement that's going to protect my client, and it's going to say something like, if you join my company, start again. When a female employee becomes pregnant, she lets us know at the earliest stage possible so we can make the health and safety standards necessary for you to do your job. We like to have this information written at the earliest stage possible so we can protect you and your unborn child. Now, that maternity statement there protects the business, because what you've done is you've delegated responsibility and authority to your member of staff to let you know when they're actually pregnant and they conceive a child. And it protects you because you don't want to dismiss somebody that's pregnant, and, you know, it's a defence document because they should have told you. And two, you know, the recommended lifting for a woman when she isn't pregnant is actually only 15 kilos. And when she is pregnant, what you should be doing is a risk assessment to assess what she can lift and ask her questions about her pregnancy. You can only do that if somebody tells you. So you're saying you've got to tell me at the early stage, and if you don't tell me and then you claim you lost the baby because of me, I've got proof that you never told me. So it's a good defence document. Holiday policy. You know, you can have a holiday policy that tells people when and when they can't take the holidays, when you recommend they take them, how much notice, etc. And to tie it in with your busiest times and quiet times, you can have a holiday policy that says that. Sickness and stress. What about a sickness policy excuse me, and a stress policy? And some industries scream out more than others, but a sickness policy where I said you do return to work interviews after one day to manage the odd dayers, to manage long-term sick, to manage sickness and depression. And then also a wastage policy, which saves you money and helps you grow your business, where if somebody's maliciously damaging your stuff, if somebody is you know, if they're damaging your vehicles, if they're losing shutter keys, if they're all reordering stuff, over-ordering it, there's a wastage policy in place that allows you to claim that money back from your staff. And remember, any overpayment of wages, any overpayment of holidays, any money you want to claim from somebody's wages, you have to have a written policy in place in your handbook that allows you to do that, okay? It allows you to do that, because if you haven't got a written policy, then that's a legal deduction from salary. Again, huge complaint in tribunal. Training policies, data and invention. Somebody's working on something, they're working for you. Imagine if I worked for Sir James Dyson. I'd love to work there. How interesting would that be? How interesting to work with somebody who's got loads of ideas, you know. But if I worked there and I was working on an invention and discovery for Sir James Dyson, and then I took that home with me and kept all the prototypes, etc., has he got a handbook that says anything that you work on with me in your handbook belongs to me during my work hours? So how about inventions and discoveries? You might not think that's relevant to you, but if you're working, some of our clients work on, there's one client that actually produces a lubricant that and oil and something that goes inside petrol that stops the fungus and mold building up inside vehicles. We've got another organisation that designs games for Sony. You know, we've got lots of different clients that work on inventions and discoveries. One is a gunsmith, and they're working on a new prototype for guns and never had a protective measure and clause within the contract before we took them on that protected that prototype. The people working on it could just walked out and took it with them. There was nothing in place to protect that our client's asset in a way. So and you know, so data as well. What data policies have you got? So also probationary suitability. You take somebody on, you don't like them, and what are you going to do with them? Are you stuck with them forever? No, you're not. Get a probationary period in place. Be careful here with the Pension Act, because you have to auto-enroll after 3 months and on eligible staff, so be very careful of this. But a probationary period with a suitability clause that allows you to say to somebody, you're not suitable, please leave, here's the notice, I'm not going to go through disciplinary with you, and I'm not going to go through capability policies with you, and make it short-winded. And remember, you know, I'm giving you an overview on law here today, so I'm not going to go through the whole policy with you, but can assure you, if you've got a good probationary period, a suitability clause in there that says you don't go through capability or disciplinary procedures with somebody, I'm giving you the control to get rid of somebody quite quickly and snappy, without it tying you down for weeks on end. And then make sure, one good tip I'm going to give you here is that your policies and procedures are tailor-made according to your business. Don't copy somebody else's, because I'll be honest with you, you're going to be a loser if you do that. You've got to make up your own policies that are tailor-made for your business. Make sure they're business appropriate as well, you know, and also make sure they're reasonable. Make sure that they are consistent as well. Make sure that you consistently follow the same rules with your staff. Don't make them up as you go along, because then you are going to end up in trouble. So, top 10 hints and tips for sacking an employee or dismissing an employee and not ending up at a tribunal. 1. Have a disciplinary procedure in place. Have investigation procedures in place, disciplinary rules and procedures and written down in your handbook. Make sure your employees are aware of the procedures and what misconduct is. It's really not very nice when somebody's surprised by why they're going to get dismissed. They didn't realise that they'd get in trouble for it. We hear that one all the time. Okay, so when you have the induction, get them to sign to say, I've read and understood this employment law handbook and the procedures and what misconduct is, so that they can't then turn around and go, I didn't have a clue I'd get sacked for that, you know, I wouldn't have done it otherwise. You can turn around and say, well, yeah, you did, because you signed to say that you understood it. You know, we couldn't have made it any clearer. So you might want to revisit your induction and say, look, when you sign this, I want you to know that you have read gross misconduct here and misconduct, and you know why you're going to get in trouble. Okay, so fact. Be careful of assumption. Dismiss an employee based on assumption may lead to an employment tribunal. Let the facts speak for themselves. Aim to be fair, consistent and reasonable in the application of any disciplinary procedure, and this will help to avoid employment tribunals. Follow your processes, not somebody else's that you're ringing up for advice. Follow your processes, and when you do ring somebody up for advice, it is absolutely imperative. This is why I say to our clients, that's why you've got to have an advice system that is conducive to your contracts and employment contracts and handbooks that you've got in place. It's got to marry up, else you're going to fall foul of the law. Balanced and neutral language as well. Remain calm and in control. Just revisit that one again. Balanced and neutral language. Don't be smart. Don't write your employment law handbook in the independence language, or, you know, the best words you can use in the world, because you're not aiming at the average market here. Write it in the Sun's language that people understand. And have you ever read you know, a legal document? I have to read them and digest them for you. And to be honest with you, they could have made them so much simpler, couldn't they? So put it into balanced and neutral language, and also remain calm and in control. Even if you detest the person there and you're so happy that they're getting in trouble, remain calm and in control. Don't show emotion. Don't prejudge or preconsider. Consider and reflect. And consider the bigger picture as well. You know, at the end of the day, we don't want a tribunal. We don't want a problem. And that's why we want to get policies, procedures, documentation in place, follow the routes, because it's an investment at the start, isn't it, that's going to prevent us having a problem in the future. The same with health and safety as well. I really hope I've helped you today. I hope you found today's webinar interesting. I'm sorry about the loss of sound halfway through. I bet you were fiddling around with your speakers then, thinking it was you, and it was, I don't know what was happening here. Maybe I need a new headset or something. and I have got a backup one which I'll use for next time. I hope you've enjoyed today's webinar. Now listen, and the clients that are listening to me, if there is anything you want any help with, remember the advice line is there 24/7, 365 days of the year. That means Christmas dinner, when you're eating it, you have a problem, we're there to answer you. There's no sickness or breaks for us. We are there to constantly support you. Don't struggle writing letters and adverts. Don't struggle with documentation, policies and procedures. That is what you're paying us for. If you want to learn how to use staff appraisals, that's what you're paying us for. Remember, we're there to insure you against tribunals. We don't want you to have one, and even if you do, we're there to insure you for the legal fees, the out-of-court settlements and the compensation awards anyway. Remember, if you're not a Peninsula client, you'd like to know more about what we do and how we help people, email me. That email comes direct to me, by the way. It's my email. Nobody else has access to it. If you'd like a free appointment, some free advice, no obligation, or just like to know what we do or some advice that's for free, contact me, Amanda at peninsula-uk.com. And remember to quote my webinar number today, which is webinar number 47. And I really hope I've helped you. Thank you very much for listening to me. Please listen to my top tips. I know that it will prevent you having a tribunal in the long run. And even if you're a Peninsula client, it'll help it stop being frustrating if you get something wrong. It helps you manage things, and I hope I've helped you understand why those policies and procedures are there and how you use them as defence documents. Thank you very much for listening to me, and it's goodbye from me.